So we have envisioned this panel as a way to expand out the vision of the battles going on over abortion in courts around the world, and have included Judge András Sayo, who is a retired judge of the European Court of Human Rights, where he was vice president, and he served from 2008 to 2017. He is currently a university professor at the Central European University in Budapest, where he was the founding dean of the law program in the early 1990s. He was educated and lived in Hungary under communist rule, and during that time he founded the League for the Abolition of the Death Penalty, which was instrumental in the abolition of the death penalty after the collapse of communism. He participated as an expert in constitution drafting in 4 countries in the early 1990s and served, including South Africa, I believe, and served as legal counsel to the first freely elected president of Hungary. Judge Sayo has taught extensively in the United States, including at the University of Chicago, Cardozo Law School, NYU, and Brigham Young University. His publications focus on constitutional theory and comparative law, as well as socio-legal issues. And his current research, which is absolutely fascinating, focuses on the demise of constitutionalism. And he's also, we're very fortunate to have him as a visiting professor at Harvard Law School this year. So welcome, Judge Sayo. And we want to continue the discussion from the first panel. And this, although this may seem very basic, I think it's worth setting out explicitly, because the opportunity structures for courts depend largely on the normative universes that they draw upon, the institutional mandates and capacities, and the procedural postures that the cases are brought to them in, which was referred to in the first panel, but I think we're going to explore it just a little bit more. So in the context of Mexico, the role that federalism played, both in terms of the origins of abortion in the Mexico City case, and also the challenges to it, was mentioned quite a bit. And I was wondering whether either of you could comment a little bit more on sort of the evolution of how the court has managed to deal with states' rights over the course of these years, and possibly also the influence of the 2011 reforms and the different relationship with international human rights law.
Well, I think that we were, I think it's worth mentioning more the 2011 reform and the 2013 reform to the Ley de Amparo, which I think a lot of the cases we're seeing now are directly related to that. In 2011, we had a major reform of our Constitution. It established in the Constitution human rights, and we abandoned the concept of civil liberties. And Article 1 of the Constitution established that that in Mexico, treaties that contained human rights had the same level as the Constitution. And we debated a lot about what that meant and how that meant, and eventually we got to the point where we concluded that it was very similar to the U.S. incorporation doctrine, where we incorporated into our Constitution all treaties that have human rights. And that had a tremendous impact on how judges decide cases in Mexico. These issues sometimes seem a little nuances, but when a judge has to confront a case and he has to cite constitutional law, and he doesn't have to just cite constitutional law, but he has to cite treaty law, and treaty law will invalidate because it's at a constitutional level, secondary laws. Then you have judges having, even if their personal beliefs are different, they have to dialogue and discuss with treaty obligations which Mexico has entered into in the human rights field. And that really expands the way a judge can see and decide a case. And that's been fundamental with gender issues. It's been fundamental with health issues, and it's been fundamental because those rights have always been in the Constitution on a social level. Usually, for a long time, they were seen as non-justiciable. And now you're really starting to see judges and circuit courts discuss these issues in their adjudications. Another important issue is the amparo law. Before, we had very strict procedural rules, like I mentioned earlier, on standing, on ripeness, on moot. And the new law really abandoned the old criteria, and that's allowed a lot of people that would normally not have access to courts be able to have their cases heard in courts. And obviously that has an enormous impact on sectors of society that have been historically discriminated against. And it's really opened up the floodgates. And I think that's why you're starting to see now a lot of issues that before it would be very hard for them to get to court. As to the federal state issues, I think that's starting to change. I think most of the judges today would probably find a constitutional right to abortion. We just haven't had the case yet that has gotten to the court. It'll come eventually. But I think right now the mixture of judges would probably, and I don't want to speak for anybody else, but I think they would probably find against a state issue on abortion. The case I described today was issued, and I think I should have explained this before, by a five-panel, a panel of 5 justices. The way the Mexican court works, we can sit en banc, all 11 justices, or we can separate into 2 5-judge panels. This was one of the 5-judge panels that decided the case unanimously, I think. And we still haven't gotten a case where en banc we confront the issue of whether there is a constitutional right to abortion. But I think the votes are there.
Oh, would you like to add something?
Yes. Tenemos que ver que México ha cambiado mucho en los últimos años.
We need to consider that Mexico's changed a lot in the last couple of years.
Hace 50 años el sistema de salud mexicano era bastante primitivo y deficiente.
50 years ago, the Mexican health system was pretty primitive and deficient.
La política internacional obligó a los estados como México, América Latina en general, a restringir el crecimiento demográfico.
International policy required that Mexico and a lot of countries in Latin America restrict demographic growth.
A partir de la presencia de McNamara en el Banco Mundial, se condicionó la posibilidad de obtener préstamos a restringir el crecimiento demográfico.
With McNamara and the World Bank, we were able to get loans to be able to restrict population growth.
La preocupación de los países poderosos económicamente era el peligro del crecimiento demográfico.
The big concern of the powerful nations was the population growth of other countries.
Fue entonces cuando se planteó la necesidad de educar a la población, de facilitar el control natal y de fomentar en cierta medida la decisión de las mujeres a que si querían tener o no una descendencia más numerosa.
This is when we began to consider access to birth control and whether women could start to consider how many children they wanted to have.
La política internacional, debemos de recordar el caso de China, que era una familia, un solo hijo para reducir su crecimiento demográfico.
We have to remember, for example, in international policy, China's one-child policy.
Y aunque los estados, como los estados mexicanos, los estados de la República Mexicana, no aceptaban la reducción de la población a través del aborto,
And even though Mexican states did not allow for the restriction or the restriction of population growth through abortion,
la cantidad de mujeres que perdieron la vida al tener que practicarse abortos llamados clandestinos hizo que las autoridades reflexionaran de la necesidad de que el sector salud proveyera ese servicio.
the number of women that were losing their life due to clandestine abortions led the health sector, the Ministry of Health, to have to think about how they were going to protect these women's lives.
Y hemos pasado de unas posiciones radicales que impiden que se practique el aborto, por lo menos en las clínicas públicas, a una posición en que facilitan las clínicas públicas la interrupción del embarazo.
And we've moved from a radical position where public clinics were not allowed to provide abortion to public clinics facilitating access to safe abortion.
Se convirtió en un problema de salud pública el cómo proveer de los servicios de una forma lo más sana para la mujer.
Therefore, it became a public health problem of how we could provide these services in the healthiest way possible.
El esquema internacional, los cambios que se vinieron dando en Europa, principalmente en los países de la Europa que no estaban tras la cortina del hierro, de hierro, porque ahí sí se facilitaban la interrupción del embarazo, hizo que se replanteara políticas públicas como en la Ciudad de México, la más poblada, que permitiera poco a poco estos cambios legislativos.
Changes in European policy, particularly countries that were on the other side of the Iron Curtain, because on the eastern side of the Iron Curtain, abortion was legal and accessible, allowed for places like Mexico City to be able to reconsider their abortion policy.
La Ciudad de México y Oaxaca son las dos únicas entidades, como nos decía el ministro Alfredo Gutiérrez, que permiten la interrupción del embarazo sin penalizarlo.
Mexico City and Oaxaca, as Justice Gutierrez was telling us, are the only states where abortion is allowed without, where it's not penalized.
Podemos ver qué tan dramático es la situación en las comunidades en donde no existen los servicios de salud que permitan a las mujeres obtener ese servicio.
We can see how dramatic the situation is in communities where there are no health services to enable women to access the service.
So I want to now turn to you, Judge Chayo, and to a very different context and a very different tribunal with the European Court of Human Rights. And perhaps you can just say a word about, it's an incredibly important, for those of you who don't work in Europe, an incredibly important site for the construction of rights narratives, often cited by the Inter-American Court and used in Latin America as well. And if you could talk a little bit about how it is situated in the Council of Europe, the norms that it draws upon, and as Justice Gutierrez said, you know, they have switched to this social rights, but that's not really relevant in the context of the European Court in the same way.
Thank you. So just to give you an idea, the court deals with 47 member states, 800 million people, and after exhaustion of domestic remedies, each and every individual has the right to sue the state. There's a major breakthrough in international law that individuals have standing against a state. But of course, this is an international court, regional one. The substantive law is limited to first-generation rights with some extensions, and that international nature explains certain limits the court is forced to accept or the court itself is willing to accept. Now, this, I think, can be illustrated in the context of choice or reproductive rights. The convention obviously has no specific language on this matter. It has language on prohibition of inhuman treatment, and that entails protection of bodily integrity in certain circumstances, and also a positive duty of the state to protect it within limits. There's a second relevant provision in the Convention, right to private life, and here where most of the abortion-related cases came in. However, in a very ironic way, because the case which interpreted a right to private life as a right to self-determination and therefore a right of a woman to self-determination in matters of abortion was one that originated from Germany, where in 1975 the German Constitutional Court found that there is a certain duty, constitutional duty under the German Constitution to criminalize abortion. And this was, at the end of the day, upheld by one of the then existing bodies of the convention system. So once again, exactly in the case where a kind of right was recognized under right to private life was the one which said that yes, but this is something where there's a large margin of appreciation. Member states have a certain better understanding of what their values are. Now,
Sorry, could you just explain for the group what the margin of appreciation?
okay, so the margin of appreciation is that the states have a certain kind of discretion given their understanding of the situation, or given that they are just free to determine within limits what the scope of a right is, or how a right is actually enforced, etc., etc. And I would like to jump to another example of this margin of appreciation that, in order to help you to understand. So gradually in 43 countries out of 47, abortion became legalized, if not as a right, but at least something that cannot be stopped on legitimate grounds. So this was, for example, the case in France, where legislation liberalized abortion, and the Constitutional Council said there is no ground in the Constitution to restrict that decision of legislation. So it was not really an affirmation of a right, but much more an acceptance of a democratic decision. Again, this is the 1970s, so situation might be different today. Now let me jump to the Republic of Ireland, where the Constitution limits, or limited until the referendum considerably, or nearly absolutely, except very specific health indications, the right to abortion. Actually, it was criminalized and not possible, except because of an amendment to the Constitution, very specific medical conditions. In that case, and this will give you an idea of what margin of appreciation may mean, the court recognized that in Europe there seems to be a consensus that you cannot criminalize abortion, at least in the first trimester, etc. But then they said, as to Ireland, we will accept that that is a specific moral issue, a sensitive moral issue for the Irish society. Therefore, whatever we held as a common position in Europe is subject to exception. So because of the idea of a margin of appreciation. So there is no overall all-European judicially enforceable right as such in this context. There will be exceptions, you will see if the discussion gets there, but because, once again, the attitude of the court is kind of deferentialism or deferentialist, at least when the Irish case A, B, and C came to the court, it's moved already in this deferentialist position. The right to abortion as such was not recognized, notwithstanding the fact, as a right applicable to all European countries, notwithstanding the fact that it is recognized as part of self-determination, part of private life. But it can be overruled, if you wish, by other considerations. A right here is subject to limitations. The limitations are to be determined by the state. And here a moral consideration was enough for the European Court to allow margin of appreciation for the state. Just because I am here to give you a very neutral description, but I would like to flag that this was an extremely divided judgment of the court.
I'm just going to reverse the table tense because someone mentioned to me that we have these backwards. Very careful audience, gotta say.
So on that question, I would like to turn to you, Justice Gutierrez Mena, and I mean, both of you have discussed how in Mexico the situation is extremely polarized. This latest judgment configures the right to abortion within healthcare and access to healthcare would seem to impose on states, even with this condition of polarization, that they have to pay for public health facilities to allow women to access abortion, even when the local consensus is quite averse to that.
Yes. I think it makes it justiciable. I think denial of access, I think after this case, you will be heard in court, and you will probably be heard in federal court. And I think the issue there will be if the state has a right to life embedded in its constitution, whether that is constitutional under the Constitution. And I think we're setting the groundwork to have the case get to the Supreme Court. This isn't the case, but I think this is a first step getting there. And I think that's how it's going to work. You're probably going to have the denial of a service, and then you're going to have challenged, and this is going to be precedent for the challenge. And chances are it's going to be in a state where the state legislated right to life in the state constitution. So that's going to be challenged in the suit. And eventually, I think that's how the case is going to get to the Supreme Court. And I don't want to predict how the court's going to decide, but I think there's a good possibility that they will reaffirm this decision in banc. So the short answer is yes, but I wouldn't be too optimistic that there will be compliance, and it'll probably get to court and move its way up to the Supreme Court.
So Justice Gonzalez Alcantara, I have a follow-up to that, which is, as has been mentioned, this protection writ mechanism, or amparo, which was significantly revised in 2013. And if you expect this to open a floodgate of cases, you know, how do you see the courts dealing with all of those amparos, and perhaps because it's a very different kind of procedure than we're used to in the United States, explain just a little bit of when those amparos go and get reviewed by the Supreme Court of Justice as well. In Colombia, where they have a similar mechanism called the tutela, Justice Manuel José Cepeda has said that the tutela forms a bridge between the Constitution and Colombian reality. And I'm wondering whether you think in some ways that the amparo can function the same way and help consolidate jurisprudence.
Desde luego, suponemos que el amparo va a facilitar el acceso a esos servicios.
We expect that the protection will enable access to those services.
En el caso que nos planteaba el ministro Alfredo Gutiérrez, tenemos el factor tiempo.
As Justice Alfredo Gutierrez was stating, we do have an issue of time.
Cuando los servicios de salud del Estado, que tienen muchos millones de derechohabientes,
when the state's health sector has millions of people who have the right to access those services,
y en un caso concreto llega una persona a demandar esos servicios y se le niegan,
and in a specific case where somebody would access these services, would request these services and they would be denied,
y obtiene el servicio en una clínica privada mediante un costo adicional,
and if they have to go to a private clinic and pay for the service,
la resolución del ministro Alfredo Gutiérrez condena al Estado a indemnizar a esa persona de los gastos efectuados
the resolution is that the state would have to reimburse the individual because of the expenses incurred from having to pay for the service.
pero además pagar el daño moral que le causó y el daño económico que le implicó el retraso en la prestación del servicio al que tenía derecho.
And also pay for moral damage and also economic damage incurred because of delays in accessing the service.
Lo que va a obligar a todas las autoridades de los hospitales públicos a entender la problemática que representa el negar el derecho a ese derecho que tiene la mujer.
This is going to force state health sector to start to think about how they're going to ensure access to the services.
Y a través de los amparos, como fue en el caso particular, se resolvió que el Estado tiene la obligación de proporcionar los servicios.
And the protection writ established that the state has the obligation of ensuring access to services.
Y la resolución es ejemplificativa para el sector salud y para las mujeres que tienen ese derecho.
And the resolution is an example for the health sector and for women who have the right to use the health sector services.
Todo el aparato de justicia federal tiene a la Defensoría de Oficio.
The justice system has the Defensoría de Oficio, somebody can help me? The defense of public defenders,
Con lo que se facilita la posibilidad de obtener el amparo para que proporcionen el servicio.
that enable access to protection writ to be able to argue these cases.
So the move to make abortion a right to health issue and to move it into the health sector also implies some challenges. And even though it is not configured that way in the European system, some of the cases, ABC and Ireland, as well as TZIAC, confront the issues when a health system, when there are differing opinions about the severity of a health condition, when doctors are conscientiously objecting to perform an abortion procedure. So first, I'd like to turn again to you, Judge Shayo, and talk about how the European Court has approached reining in some of that discretion on behalf of the medical profession in determining rights.
So once again, there is some protection to the, not to the right of choice as such, but there's another aspect of private life which is again has to do with physical integrity. It's not a right to health in the Mexican sense or in the sense of social rights, but it's still part of private life. So there is a recognized right in that respect. And that comes in even when the state otherwise prohibits abortion. And again, the cases are coming from Ireland and Poland primarily. And the court's position is very legalistic. It's basically neutralizing the substantive issue, turning it into a rule of law procedural issue. So in case there is a authorization for termination of pregnancy on medical grounds, but this possibility, and this is required by the court, you really have to allow protection of life under another article of the convention, or physical integrity, meaning detrimental health condition. So in that situation, the court will look into the procedural guarantees to make that right to be efficient. And they will look into legal certainty. And that's basically what the court is doing. Is the legal environment sufficient to guarantee that the medical service will be provided? We never had a case where this was related to conscientious objections directly, but it's very clear that the underlying problem, for example, in Poland, that there is total lack of willingness to engage and create clear rules, or in one of the specific cases, the doctors felt unease, perhaps under pressure. So they just did not provide proper advice, they did not provide the information in due course, etc., etc. So there is an underlying structural problem. But the court does not address that, it just looks at the formal possibilities. So it's really, as I say, it's a rule of law issue for the court, which of course helps the court to avoid the hot issue. And that's where the court is. Again, it has to do with this difficulty international courts face because of growing pressure coming from member states threatening the court that they will not pay or they will withdraw, etc., etc. So that is perhaps one of the reasons. It's not a principal reason, I'm afraid.
I think that's very important to point out, that the court is operating within a larger political context. This particular opinion that you write just now, Justice Gutierrez Ortiz Mena, has a lot of language around taking a gender perspective, and as you spoke, taking a gender perspective. It cites not only international law, but general comments, which are not necessarily binding to guide interpretation. So how important do you think it is that the Mexican court sort of name and formally declare these are reproductive rights and we are adopting this specific perspective?
Well, I think it's very important because you're framing the issue on a constitutional level again, and you're abandoning the Mexico City 2007 case where you just said it was a state issue and sort of punted the ball to the states. So I think it's very important. I also think it's very important citing international law. As I mentioned, Article 1 of the Constitution now incorporates those rights into the Constitution. So you have to address those international bodies of law. And soft law, I think, is very important also. And more the court is starting to use sources of soft law for guidance when deciding and adjudicating cases. So I think it's very important.
So I'll play devil's advocate here a little bit and say that there are some courts, not just in the United States, but even the Argentine Supreme Court, that has felt that the proliferation and fragmentation of international law, and especially soft law, makes it very difficult to cite it in a coherent way or integrate it in a coherent way into constitutional law. I don't know if you or Justice Gonzalez Alcantara want to address that.
Well, I think the fact that it's not easy isn't an excuse for not doing it. Of course it's difficult, and of course you're going to have a lot of challenges, but the language the court uses has evolved tremendously. 8 years ago, if you were to present, when I just arrived at the court, citing soft law or citing international cases, we would have discussions whether we could cite to international law or not. And today, I don't think there's a single justice on the bench that would argue that we cannot cite to international law or that we cannot cite to soft law. So there's a constant evolution going on. And yeah, it's not easy. It's quite hard. There's a tremendous amount of body of law which you have to take into account. But I think that's part of the job.
Sí, sí. Es muy importante este tipo de encuentros
These kinds of meetings are really important
porque nos permite conocer las posiciones de lo que pasa en otras partes del mundo.
because they allow us to see what's happening in other parts of the world.
Brillantemente conocemos las resoluciones del Tribunal Europeo de Derechos Humanos
Brilliantly, we now know the decisions of the European Court of Human Rights
y los problemas que representan la fuerza de los sectores religiosos y con los ejemplos de Irlanda y de Polonia.
and the problem of the forces of religious forces that we've seen in cases such as Ireland and Poland.
Y en América Latina encontramos el mismo problema con las resoluciones de la Corte Interamericana de Derechos Humanos.
And in Latin America, we've seen these problems in the Inter-American Court of Human Rights.
Desde luego que el tamaño de la Corte Europea frente al tamaño de la Corte Americana es totalmente distinto.
Certainly, the size of the European Court is very different than the size of the Latin American Court.
Y ese esquema que nosotros tenemos poco a poco estudiando, citando, conociendo resoluciones de países tan lejos como puede ser Sudáfrica,
And the framework that's established by understanding, studying, and citing cases that are so far away, such as, for example, South Africa,
nos permite ver soluciones que se presentan en otras partes del mundo para nuestra sociedad.
allow us to consider solutions that have been proposed in other parts of the world within our own society.
Pero aún en México, en el caso mexicano, tenemos problemas por la posición política y religiosa de las entidades.
But in Mexico, we have the problem of the religious positioning of certain states.
De ahí que nosotros, el sector salud es un sector centralizado, federalizado,
Now, the health sector is centralized and federalized,
con lo que estamos haciendo cambios a la legislación de todas las entidades, facilitando el derecho y el acceso a la salud de las mujeres.
Therefore, we're making changes in state legislation enabling and facilitating access of women to health services.
Si bien tenemos casi medio siglo de diferencia entre la resolución de la Corte Americana y las resoluciones de la Corte Mexicana,
We may have half a century between the resolution in the US court and the Mexican court.
creemos que vamos en el camino correcto.
We think we're going in the right direction.
Ahora, cualquier violación es analizada por una ley federal que obliga a las entidades a interrumpir el embarazo.
Now, any rape is able to be considered by the Supreme Court as at a federal level as a lack of access to the right.
Y la discusión es muy fuerte y poco a poco iremos viendo que todos los derechos se expandan en el territorio nacional.
And this is a very important discussion, and we're working towards expanding this right at a federal level.
So we've heard quite a bit, and it's really quite impressive the way that constitutionalizing these debates has transformed them. Moving from the clash of absolutes, as Justice González Alcántara started, to a more nuanced understanding of competing rights and balancing. But I'm wondering whether in the European context, you would say the same thing is happening, or whether it remains a more traditional dichotomy.
The issue of dichotomy has to be seen in its own historical dynamics. So there are cycles, and seems to me that it may come back at this present constellation, and it has to do with a general shift in political attitudes. As to the European Court of Human Rights, the court, again, perhaps because of its position, its delicate position, was very reluctant to go for absolutes. It's always about proportionality and balancing and so forth. So one important element in not taking position is that they refuse to determine when does life begin, saying that there is no medical or social consensus in Europe on that matter. This was in a case totally unrelated, by the way, to abortion. It was a medical malpractice case. So it's very, in reality, they try to some extent to diminish the strengths of rights on both sides, except once again when it comes to the woman's right to life or health, when at least some procedural guarantees are to be in place. Otherwise, yes, there is self-determination, but it cannot be prevalent. And on the other hand, yes, there is perhaps right to life of the unborn or nasciturus or fetus, but we don't know from which point, therefore it cannot be really used as the basis for determination. If I may add one more point on indicating the difficulties also where perhaps major challenge will come. There are French cases where pharmacists refuse to hand out a day-after pill on the basis of religious convictions. It's a matter of conscience, which is protected by the court. And it was not even a judgment, just a decision saying that France has the right to deny that request or argument of the pharmacist. This cannot be, for the European Court, a genuine matter of debate as in terms of conscience. Now, there is a parallel case which was never taken up by the European Court in Germany, where most of the hospitals are under one or another church. In one of the hospitals, after a rape event, denominational hospitals, which are once again the majority, did not inform the woman who went to the hospital right after the rape about the possibility of a day-after pill as a measure, obviously, to be taken under those circumstances. Because they were obviously under instructions coming from the hospital director, who had to follow certain guidelines of the church. It was a Catholic church in this case. So this case never came to the court, but imagine with this laissez-faire attitude the court has, what are they going to say? Okay, if this is the situation in Germany, if they would like to take into consideration conscientious objection, if this is a church matter, you can restrict the right of the woman in favor of religious considerations. So in a way, with this attitude, the outcome is that you don't have a principled response to a very complex situation.
And so just a tiny follow-up on that, are you suggesting that the court would be better placed to go to the substantive issues more broadly,
The court did that in earlier days, in many areas, without much concern, and those judges were convinced that this is a human rights document, and human rights are universal, and in this case, they have a regional application as universal human rights. And those rights mean the same everywhere. Of course, there is a context-based balancing necessary, but that's not a ground not to be engaged in this. And somehow, for reasons I tried to explain, this attitude is less and less present in the judgments of the European Court. But in many areas, let's take legitimate children, when in most European countries there was a discrimination to the detriment of illegitimate children, other courts said, okay, there is a growing trend to, because this is a violation of fundamental principles of equality, and there is a growing trend which was not really present, relying on soft law, part of the soft law, because the other part of the soft law said the opposite. They said, okay, this is unacceptable. And this applies across the board to all countries.
I have a number of other questions, but I'm also conscious of time, so I want to open it up to questions and discussion with the audience.
I will sneak in a question if that's okay. So during the pendency of this event, the US Supreme Court granted cert on a case that is almost exactly like a case it decided 2 years ago with a different court, Whole Women's Health. And it makes me want to ask about the stability of precedent in the two courts we're talking about as compared to the United States. So even if you build your ideal version of the abortion jurisprudence, do you have confidence that it will sustain, or do you feel as though changes in your court's personnel really do have a capacity to radically change course?
That is a very, very interesting question. First of all, let me start by giving some distinctions between our court and the US court, because I think our stability is achieved in a different way. In the US court, you have lifetime appointments. And I think that gives certain stability to certain decisions, and you have a system of precedents which is different from our system. We have 15-year appointments, so you're constantly seeing about every 2 years, 2 judges retire and 2 judges come in, more or less 2.5 years, you start seeing that rotation. So that would tend to give a bit of instability. But the way we decide cases and the way the law makes us decide cases, the Constitution, gives it a bit of stability. For example, there are 5 ways a case can get to court. 2 of them you don't have in the US, which is when a state or the federal government challenges a state act or a federal act, either one, on an invasion of the other's jurisdiction. And each of the states can challenge the other states, and we will decide en banc. Or a legislative minority, 33%, can challenge a law without case or controversy, and we will decide the constitutionality of the law in abstract. For both of those type of cases, for us to decide a case, we need 8 votes. And that gives a lot of stability. So that's, you're building in precedent into the system because you need 8 votes, or if you want to see it the other way, 4 judges can veto a decision. So precedents become important not because of the lifetime appointment and the slow turnover of justices, but because of the way the system is designed. So I think the precedents we set now, I'm very, very hard pressed to see a change in the political philosophy of most justices. In fact, this administration has expressly stated that it wants to balance the gender composition of the court. Right now, there are 9 men and 2 women on the court, and the executive branch has been explicit in saying that future nominations to the court, and this executive, I think, will have at least 2 more justices that they will propose women to the court. So I think that's going to have an impact on, especially on these issues down the road.
If you have a question, please do line up behind the microphone.
Thank you. Barbara del Castillo from Mexican Consulate. ¿Qué mecanismos de difusión tiene la Corte en México para dar a conocer a la mayor parte de la población el contenido de resoluciones que son muy sensibles para la población que probablemente no tiene acceso a este conocimiento?
What are the mechanisms that the Supreme Court of Justice has to educate the public and make them aware of the resolution of these issues, which are very pressing for them?
Uno de los problemas más grandes que tiene el mundo en general
One of the biggest problems that the world has in general
es la difusión de sus resoluciones judiciales.
is communicating judicial resolutions.
El lenguaje que hablamos los abogados, y aquí hay muchos,
The language that lawyers speak, and there's many of us here,
es totalmente inentendible para el resto de la sociedad.
is completely mysterious for the rest of society.
Hablamos en clave, utilizamos una terminología equívoca para la población.
We speak in code and we use language that is ununderstandable for the rest of the population.
El difundir las resoluciones y explicarlas a la sociedad es parte de la tarea de las nuevas cortes.
And it is the role of the new courts to be able to explain to society what our resolutions are.
Si bien en una primera instancia estamos enfocados a educar a los jueces y a los abogados,
Our first charge is to educate judges and lawyers,
el destinatario final es la población en general.
but the final destination is the general population.
Hace algunos cientos de años las resoluciones se escribían en latín,
Hundreds of years ago, resolutions were written in Latin
en todo el mundo.
and all over the world.
Actualmente las traducimos y las difundimos, las resoluciones explicadas para que las pueda entender una persona normal.
Now we translate that and we communicate them in a way that a normal person can understand them.
Difundimos las resoluciones a través de la televisión y la radio.
We communicate our resolutions through television, through radio,
Y así hacemos que la gente se interese en lo que estamos resolviendo.
and that's how we get people interested in the work that we're doing.
Es la única forma de llegar a la población en general.
That's the only way to get to the general population.
Si la gente siente que las resoluciones afectan su vida cotidiana,
If people feel that the resolutions affect their daily life,
entonces estarán interesadas en saber qué resuelve el juez y qué resuelven los tribunales.
then they'll be interested in knowing what the court and the judge has resolved.
Y es por eso que ahora tiene más conciencia la sociedad de la importancia de las resoluciones de las Cortes Supremas.
And that's why people are now more interested and more aware of the importance of Supreme Court decisions.
Nos preguntan cómo podemos mantener cierta estabilidad en nuestras resoluciones.
You asked about how can we maintain certain stability in our resolutions.
En ninguna parte del mundo se podría pensar en regresar a establecer la esclavitud,
In no part in the world would we ever imagine going back to slavery,
porque la libertad del ser humano es algo que hemos ganado en todo el mundo.
because we have won freedom for the individual everywhere in the world.
Por eso las Cortes Supremas, los tribunales y los abogados
That's why the Supreme Courts, the judges, the lawyers,
estamos convencidos de que lo que se resuelve es parte de la sociedad y hay que defenderla todos.
and part of what we decide is part of society, and we all have to defend it.
Actually, I'd just like to, before the next question, ask Judge Shayo about this, because I think sometimes we take for granted that it is a progressive conquest of rights and democracy, and we live in a situation now where in many countries, some would argue in this country, democratic institutions and democracy are facing, if not unprecedented, very serious threats. And the idea of constitutionalism and citizens, normal citizens, engaging with constitutional law and the role of law and how important it is to their daily lives is certainly does not prevail in many countries around the world. And I know you've done an extraordinary amount of work on this, so I wonder if you'd like to comment from that perspective.
So if I may add something to your formulation, sometimes these threats come from democratic institutions or distortion of democratic institutions. As to the European Court, which is probably a canary in the mine, the court, and this has to do also with precedents, the court is very much precedent or case law oriented, but the term of the judges is limited to 9 years, and for good reasons. So there is now a new generation of judges who reflect in their philosophy the reality in their own country. And they may much more interested in national values or the democratic process in their own country being the justification. So that's point number one. I don't expect major shifts in the case law, but I can envision situations where different precedents will be quoted. And point number two, that the framing of the problem will be completely different. So what is undue burden in the equivalent of undue burden here? That may be a matter for the European Court to be left to the national courts, which may have very different understanding of what undue burden is. Or the second element that I would like to highlight in this context, how the European Court is perceived in these 47 countries. And it's not, it was headlines that the Supreme Court of the United Kingdom, or no, the Court of Appeals judges were called enemies of the people, and there was attack also on the Supreme Court. Now this was not very, this was a shock for British judges and people who consider the courts being a bastion of constitutionalism. It was not a surprise to me, because it was not me, but my colleagues who were called by Daily Mail clowns of Europe. And that was the attitude of newspapers, because they consider, or some of them, again, Daily Mail being the most influential, they consider this a matter of national sovereignty. And they are very much against the idea, and there were similar voices here in the Congress of this country. They consider that judgment rendered by so-called foreign judges has no legitimacy. Foreigners know nothing, not to speak of the superb quality, which is true, of English or British or UK judges. So why are they telling us what the law shall be? So it's a major legitimacy issue, which, of course, threatens the possibility of regional or global standards and pushes countries back to a more closed society where indeed the democratic process is losing one of its external, very important controls in matters of human rights. So I think that's really the stake here.
Hi, Jake Shurko at the Edmund J. Saffer Center for Ethics and here at the Petrie Flom Center as well. Judge Sayo, you raise a very interesting point relative to something that was discussed earlier. And one of those questions relates to the persuasiveness of judgments of courts from other countries, and especially with respect to individual states in Mexico now. And so I guess my question for the justices is how persuasive are in fact the judgments of some of the other courts, especially in Latin America, where abortion is much more heavily criminalized than it is in Mexico now, given that it seems like the Mexican Constitution and Mexican society is becoming more liberal. So to the extent that they are persuasive, right, to the extent that these are important decisions to take into account, this kind of external check, as Judge Sayo was mentioning earlier, one way of looking at the decisions of courts such as in El Salvador is in fact doing the opposite of what the Mexican Supreme Court is doing now. So I'm just curious how the justices think of their role in looking at the judgments of other countries, especially in Latin America, with respect to this issue, which seems to be orthogonal to the direction that the court seems to be going now.
One of the things that surprised me a lot when I got to the court was just how much of a constitutional dialogue there is with other Latin American courts. It happens a lot. Colombia, Argentina, Brazil, we're constantly reading each other's rulings. We're constantly plagiarizing each other's rulings. I shouldn't say that. Citing. But there's a lot of dialogue between courts in Latin America. One of the things we were able to do with the change in 2011 between with the constitutional changes, Article 1 of the Constitution, which we incorporated treaties, we also said in that case, in those two cases, that the rulings of the Corte Interamericana de Derechos Humanos, the Inter-American Human Rights Court, are binding on federal judges in Mexico when Mexico was a party, and they are citable precedent, even if Mexico was not a party to the cases. So we very much read what the Inter-American Human Rights Court does. I know other countries in Latin America have taken the exact opposite step. And we do sit down and we do discuss these things and we do talk about these things. And there is a lot of reading of the other cases. So there's a lot of constitutional dialogue in Latin America, more than one would imagine.
Would you like that?
Hay que entender a México ahorita del México de hace 20 años.
You have to understand Mexico now from Mexico 20 years ago.
Hace 20 años teníamos la misma política de los Estados Unidos que no acepta que ningún tribunal internacional le diga nada.
20 years ago, we had the same policy as U.S. that doesn't accept that any international court can decide anything for the U.S.
Lo que nos comentaba nuestro amigo europeo de Hungría, de que cómo van a venir del extranjero a decirnos qué tenemos que hacer, es algo que estaba en el ADN de todos los jueces latinoamericanos.
Just as our European colleague was mentioning, how dare somebody from another country come and tell us what to do was definitely in the DNA of every Latin American judge.
Pero la apertura de los tribunales mexicanos y de la Suprema Corte en concreto todavía no es una batalla ganada.
We still haven't won the battle of opening the judges on the Supreme Court and the Supreme Court.
La resolución del ministro Alfredo Gutiérrez, que cita jurisprudencia de otros países, no es bien vista por todos los ministros.
Not all the justices see in good and favorable regard the decision of the justice to cite treaties, international treaties.
Pero yo creo que podemos aprender de la experiencia de otras naciones y de otros juzgadores.
But I think we can learn from the experience of other countries and other judges.
El conocimiento es universal y debemos de aprovecharlo.
Knowledge is universal and we need to use it.
And on that, I'd like us to thank Judge Sayu and the two justices and Cristina, and we'll move to... in this last panel, we'll really see how the law gets socio-legally translated into different women's lived realities. Thank you, and we're going to go right into the next panel. And I leave it in your hands.
Go get my papers. So I'm just going to get started introducing our distinguished guests. Should I go ahead and start? So Jocelyn Viterna is a professor of sociology and co-director of the Transnational Studies Initiative at Harvard University. Her research examines how social mobilization affects gender norms, gender practices in states, in welfare, in institutions, and in communities. Currently, Viterna is developing two new research projects. The first investigates the effects of revolution on the social organization of medicine, The second demonstrates how potential aid recipients in developing nations actively recruit transnational NGOs to place development projects in their communities, and details the consequences of winning or losing these local-level competitions for foreign resources. Paterna's work has been published in the American Journal of Sociology, the American Sociological Review, Politics and Gender, and the Latin American Research Review, among other journals. Her book, Women in War, The Microprocesses of Mobilization in El Salvador, 2013 Oxford University Press, won 4 Distinguished Book Awards, the ESS Myrna Komarovsky Award, the ASA Section on Sex and Gender Award, the ASA Section on Political Sociology Award, and the SSSP Global Division Award, and won honorable mention, the ASA Section on the Sociology of Development. It's currently being translated for publication in Spanish. And our second distinguished guest this morning is Marlene Gerber-Fried. Gerber, right? Is a professor of philosophy and faculty director for the Civil Liberties and Public Policy program in Hampshire College, a program for education and activism about reproductive health, rights, and justice. She received her PhD in philosophy from Brown University. In 2010 to 13, she was interim president of Hampshire College. Her scholarship and teaching is focused primarily on abortion rights and access, reproductive and sexual rights and health, and legal theory. She edited From Abortion Rights to Reproductive Freedom, Transforming a Movement, and is co-author with Giles Silliman, Loretta Ross, and Elena Gutierrez of Undivided Rights, Women of Color Organized for Reproductive Justice, November 2004, awarded the Myers Outstanding Book Award by the Gustavus Myers Center for the Study of Bigotry and Human Rights, and is currently co-authoring a book on abortion with Loretta Ross. She is also a longtime reproductive rights activist and is the founding president and served 21 years on the board of the National Network for Abortion Funds, and also the founding president and continues to serve on the advisory board of the Abortion Rights Fund of Western Massachusetts. She works on abortion advocacy internationally, previously with the Women's Global Network for Reproductive Rights, and currently with the Women Help Women. She has received several awards for her activism, including Felicia Stewart Advocacy Award, APHA Population Reproductive and Sexual Health section of APHA, Evidence and Activism Award, the IBIS Reproductive Health, and Women Warrior Award, Sister Song Women of Color Reproductive Justice Collective. And in case you're wondering why I've been up here all morning, aside from being bilingual, I'm a midwife, and I've worked in Central America and Mexico training midwives, doctors, and community health workers on full scope practice from respectful maternity care and access to abortion. I opened birth centers in Mexico, in the highlands of Chiapas, Mexico City, and have supported birth centers in all of Latin America and currently in Haiti. Right now, I'm a doctoral student at the School of Public Health, and super honored to be under the wings of Alicia Yamin. So please help me in welcoming these amazing women that make the world a better place for all of us.
Thank you so much to my fellow panelists, to Alicia, and to the exceptional panels that have come before. I've learned so much today. I've been working for the last 25 years in El Salvador, and specifically about the last 6 years on cases of abortion and reproductive justice. And so I wanted to start out today talking about a couple of different cases that really illustrate how things have been changing in El Salvador. So I want to start out with the case of Maria Virtud. This is a case that I found in a 1991 newspaper article in the primary daily of El Salvador called El Diario de Hoy. And essentially what happened in this case was Maria was pregnant with her 8th child. She had gone to the health clinic. The doctor had said she was quite a ways away yet from going into labor, so the next day when she felt the urge to defecate, she didn't think much about it. She went to the pit latrine toilet behind her house, but she accidentally birthed the baby into the latrine. She called the neighbors for help. They called the Red Cross of El Salvador, and within a few hours they were able to extract the baby, and although he was sick, he survived, and that was it. This was sort of a human interest story that came out in the newspaper in El Salvador. And certainly, I'm sure most people here know this, but it's not unusual for the urge to have a bowel movement to be the first sign that a baby is coming. You can see in these pictures that when the baby's head is passing through the birth canal, it passes right over the rectum. And if you start to look, you actually find a tremendous number of news stories about babies who are born into toilets, even when women know they're in labor, even when they're in U.S. hospitals under the care of doctors. In fact, I was telling this story to the mother of one of my daughter's friends, and she told me that the same thing had happened to her. She was in the hospital. She said she had to go to the bathroom. The doctor evaluated her. She was only 4 centimeters dilated. She went into the bathroom, and boom, the next thing you know, her baby was in the toilet. Of course, she was fine. It was in under medical care and in a very clean institution. But now let's fast forward to 2002 in El Salvador. In 2002, Mirna was 34 years old, and she was living in a poor province of Cuscantencingo, very poor family. She had to leave school in 4th grade to start working in a sewing factory. Since then, she had began to run a small store out of her home, and she was very enterprising. She was only 19 when she married Miguel, someone that her church had set her up with. And for the next 15 years, next 11 years, they had a relationship where she had a lot of miscarriages, but she never actually had a child, right? She had one child that was born but died shortly after birth. So this is, of course, what doctors will tell you, one of the key reasons to suspect that a pregnancy is going to be problematic is if the woman's had problematic pregnancies in the past. So Mirna certainly has had difficulties. When she was 34 years old, she realized she was pregnant again, and perhaps not surprisingly, she didn't tell many people outside of her initial family. She did not go to prenatal care because it cost a lot of money to travel there and to take time off work, and she had had so many disappointments in the past. She continued to have back pains and vaginal bleeding throughout the pregnancy, but she decided that she and her husband decided they were just going to leave this in the hands of God, as they tell it. In 2002, Mirna felt a sharp stomach pain. She thought she was about 7 months pregnant, and she went to the latrine, again, a pit toilet in the back of her house, to have what she thought would be a bowel movement. And to her horror, she accidentally birthed a very small fetus into the latrine. She returned to the house pale, traumatized, bleeding, sweating. She called her little sister, told her what happened. The little sister went and got the help of some neighbors. The neighbors came. One of them used a lasso. They managed to pull the baby out of the latrine, and the baby was crying. It did have sepsis and some problems, and it was very premature, but it was fine. However, when the police came, because the police had been notified that this was going on, one of the neighbors told Mirna that she was quite clear that Mirna had thrown the baby away on purpose because the baby was the result of an infidelity with her husband, that Mirna had told her her husband was sterile and couldn't get her pregnant, and her husband was going to know she was cheating if she was pregnant, and so she was sure that she threw this baby away. Of course, we already know, if you just look at Mirna's medical record, that this is wrong, right? She's been pregnant multiple times in the past. She's just had problematic pregnancies. The story gets weird here, but I only have 10 minutes, so I'm not going to go into it. But basically, this neighbor tells a story where she personally was one who heard the baby cry and rescued the baby and gave it CPR and things that don't come out anywhere else in the testimony. But by the time that the baby and Mirna get to the hospital, doctors are actually writing on the baby's medical file that the baby had apparently been thrown away by her mother. When the case goes to court, Mirna was originally charged with abortion, but in the process of the trial, the charge was upgraded to attempted aggravated homicide. And doctors testified some of the most incredible things. For example, remember that Mirna said that she thought she was about 7 months pregnant. And of course, the way we know the gestation of a baby is we ask a woman when her last menstrual period was, and we do the math, right? The doctors who testified in the trial said that the baby was actually 8 months of gestation, but it was only the size of a 7th-month fetus because it had suffered from intrauterine growth restriction. Okay, so first of all, they couldn't have known that, right? Because they didn't know when the date of the last period was. All they had to go off of was the size. And what they're saying is the size of the baby, the size of the fetus, the baby is 7 months of gestation, which is exactly what Mirna says. But they're saying it was 8 months of gestation, but the reason it had intrauterine growth restriction is because Mirna obviously didn't want the baby, and her not wanting the baby limited the oxygen and the ability of the baby to grow. So they use that as sort of evidence against her. Eventually, Mirna was found guilty of the attempted aggravated homicide of her daughter, and she was sentenced to 12 and a half years in prison. In November of 2014, the Supreme Court did finally issue a pardon to Mirna for this crime, but it was after she had served the entirety of her sentence. So this is Mirna now. She's in the black shirt here. It's her daughter Briseida, who was born into the latrine, is in the middle, and her little sister, who went to get help, is to the side. And if you talk to Briseida now, who is actually an incredible student, she's a senior in high school right now, and say how this start affected her life, she'll tell you that she has absolutely no memory of being born into a latrine, that wasn't a problem. But the fact that her mother spent the first 13 years of her life in prison and that all the neighbors talked about her mother was a baby killer, that was really a traumatic aspect, not to mention the fact that Mirna lost everything. Her husband left her and took everything with her, her job, her spouse, her money. She jokes that he left a bed, right, but took the dishes, everything else. Mirna also lost her health. She's in need of a she's had some small heart attacks since then, and just the prison conditions were really hard on her health today. So I think the question here, and I know I'm already really close to out of time, so I'm going to go quickly, is what happened between 1991, when Maria Virtud had a baby into a latrine and it was a human interest story, and 2002, when Mirna was sentenced to 13 years for the attempted aggravated homicide of her baby. And part of the story is a legislative story. Prior to 1997 in El Salvador, abortion was only legal in these three circumstances, or causales. You could have an abortion when the life of the mother was at risk, when the pregnancy was the consequence of rape, or when the fetus had abnormalities incompatible with life outside the uterus. In 1997, there was a criminal code reform where they just essentially took out these exceptions. So there's no abortions, no exceptions, not even when the life of the mother is at risk. And in 1999, the same legislature passed a constitutional amendment saying that life begins at the moment of conception. But I think it's not enough just to talk about the change in the law for two reasons. One, most of these women, like Mirna, they did not have an abortion, right? Most of them were very far along in their pregnancies and they had a difficult birth or an obstetrical emergency. And two, we also can see that places like Nicaragua, right next door, have the same law now, but they're not sending women to jail, and women still are getting life-saving abortions. And so what I think is happening is that we have to look at what the political context, the public opinion has been around this. I've been analyzing 25 years of newspaper articles about this, and I'm going to go through this quickly. But what I basically find is that there was this powerful pro-life movement that started in the early 1990s in El Salvador. And when they started in 1994 to 1996, the story was really a story of these powerful global forces that are trying to force abortion onto El Salvador, right? They would say, this was really the narrative of Pope John Paul II, in El Salvador, those powerful global nations to force didn't want poor brown people migrating to their countries. They were really trying to push population control on these countries and force them to kill their unborn babies. And you start to see this getting taken up in the legislature. It's interesting that 1994 is also when Newt Gingrich and the Republicans in the United States came up with the term partial birth abortion. So there's a lot happening in this time period. Once the elections came, it really became a sort of a story of right versus left. So the right-wing party, Arena, started saying the FMLN, the left-wing party, you can't vote for them because they'll kill unborn babies. Here's a newspaper article. If you can read it, it says, Arena proposes to defend the life of the unborn by criminalizing abortion, but the FMLN, in contrast, pronounces itself in favor of extracting fetuses, right? So really crazy language. But there's an interesting thing that happens right before the 1999 elections in El Salvador, and that's that the FMLN says to the feminists, look, we really want to be elected, we want to rule, we want to be the party of women, but if you keep touching abortion, we're never going to be elected. So let's just drop the issue. And so the FMLN kind of was told that they could vote their conscience. Most of them ended up upholding, all of them ended up upholding the criminalization of abortion. The feminist movement went silent on the issue, and yet these pro-life mobilizers kept getting out of bed every day looking for how they were going to fight for the lives of the unborn babies. And one of the things I've been arguing is that they needed that target, and they didn't have the FMLN, they didn't have the feminists, and so they started sort of targeting these evil mothers, right? And so here's an article I found in 2001. The title is Crimes Without Punishment. In the introductory blurb of this first one says, The numbers of newborns being thrown into latrines, trash receptacles, or vacant lots by their own mothers is alarming. The authorities need to capture these women red-handed to process them for aggravated homicide, but to the contrary, these crimes never come to light and they're given complete immunity. And then the story starts. Imagine yourself naked, tied at the hands and feet without being able to speak or see. Suddenly you feel yourself being thrown into a hole, and upon falling to the bottom, you realize you're surrounded by feces and urine. Little by little, you begin to drown. Soon, various insects like cockroaches begin to climb on your body. Worms and rats begin to bite you and pulling off your skin, and nobody hears your painful cries, right? And so there's no statistics at all, but this article says that, thousands of babies are being, finding themselves in this fate in El Salvador. Quickly, the one at the bottom says histories of hearts and stone. And the little sub thing under that says, they're human beings that waited 9 months in their mother's wombs for the hands of a sweet mother, but what they found instead were the talons of soulless women, right? So it was a very sort of powerful language that came. I also found some pressure to prosecute. This is in 2003. You see the Human Rights Ombudsman at the bottom, who has started an actual part of the Ombudsman's Office for Human Rights for the human rights of the unborn, and she's pressuring the head of the police and the Attorney General to do more to shut down abortion clinics, and they're saying we're trying, we're doing all we can. There's some incredible stories about this as well, but what they actually say here is that if you want us to actually stop abortions, you have to make the law even stricter. You have to make intention to abort a crime, and then we can get those women for abortion. Really quickly, my students and I have now found 71 cases like this. We've actually found over 80 now, which is why I don't want you to cite this, because the numbers keep changing. But what you can see in the first column is that most of these women are initially charged with abortion, and then over time, the charges get upgraded to attempted or aggravated homicide. And whereas the abortion charges are not often found guilty, the aggravated homicide, 3/4 of those are found guilty, and they're getting an average of 29 years in prison for this. This basically says that they're very young women with low education working in the jobs that don't give them any protections, oftentimes domestic workers, and they oftentimes are already mothers at the time of the incident, and they typically almost always require a public defender. This is just the 41 women who were found guilty. Most of them are turned into they are reported to the police by the healthcare professional who treats them in the moment of emergency. So someone finds them bleeding, unconscious, takes them to the hospital. The doctors have been told that if they don't report a suspected abortion, that they will be guilty of being an accomplice under the law, and they call to report a suspected abortion, and then that starts the process that they get upgraded to aggravated homicide. I don't have time to talk about this. Suffice it to say that women do die in the hospitals because they don't get access to abortion. But I think what's more interesting in some ways, or more common, is that women who have fetal malformations that are incompatible with life, actually, we don't know what happens in those pregnancies after about 20 weeks, because in most of the world, those pregnancies are interrupted. And we're starting to find that those pregnancies, if you let a woman go to the full 40 weeks, that there are tremendous complications on women's bodies. And young girls, 18 years old, suddenly are having their uteruses removed, and other kinds of bodily mutilations that happen with these pregnancies. So it's not just a matter of life, but actually sort of bodily integrity as well. And so I think, to sum up, because I'm way over time, the changes in the law are horrific, and we need to change the law back. But I think what El Salvador shows us, both in terms of the timing when women started to go to jail and in comparing El Salvador to other nations, is that it's not just the laws, but it's this accompanying narrative. It's the fact that the police officers and the doctors and the judges all actually operate in the society where these narratives of these evil women are circulating, and that has had a really profound effect on how the police investigate the crime scene of a uterus, and how the doctors decide whether or not to report a patient, and how judges hear the cases. And so if we change the law, I think obviously lives would be saved, particularly in hospitals, but I think the practices outlined here that have become very institutionalized in the criminal justice system are unlikely to change in part because most of these women didn't have abortions in the first place, but also because we've now institutionalized these understandings of what constitutes a crime. And I think there's also, I should say, just when you say life begins at the moment of conception, it becomes very, very difficult to determine what's the difference between abortion and homicide, right? And so there's a lot of difficulty going on here that's really being borne on the backs of low-income, uneducated women. Thank you very much.
I'm not going to use slides, so we can do whatever we need to do to not do that. Hello, everyone. I'm very honored to be here and to be part of this important discussion. Thank you, Ali. Thank you, Chris. And thank you, Jocelyn, for that great talk. It has been very inspiring to hear about the significant legal changes in Mexico and in the European Court. But I think, or no, and, not but, and what Jocelyn and I are doing is talking about the importance of thinking outside the law and to the politics of abortion. So first, I want to say that I think it's really important to ground these discussions in the lived experiences of people who are seeking abortions, sometimes getting them, a lot of times not. And the sort of larger global reality, which is that 1 in 4 pregnancies end in induced abortion. In developed countries, it is one of the safest medical procedures. But half of all abortions in the world are still unsafe. The World Health Organization estimates about 22 million a year, which is probably a very low estimate, mostly in Africa and Latin America, which have the highest rates of maternal mortality from unsafe abortion. This is, the thing I'm about to say, I think is the most important thing. If you take away nothing else, take this away. That no person today, anywhere in the world, should die from an unsafe abortion. This is not a disease without a cure. These people are dying from, they're being murdered by the law and by poor health systems. So we have the means to completely eradicate maternal mortality from abortion, and we're just not doing it. Even where abortion laws are liberalized, as we have heard a bit in the earlier panels, but I want to really focus on it. My political work and most of my adult life has been spent in this tremendous chasm between formal, legal, constitutional rights and whether you can access them, whether you can have an abortion. And as we heard earlier today, there is no affirmative duty in the United States for abortion to be provided. And so many people are living with the consequences of the restrictions. Yes, we are a legal system that's built on precedent, but right now I think most reproductive health rights and justice advocates are much more focused on the fragility of precedent rather than its staying power. And I'm going to just quickly run through the kinds of restrictions, and I don't want to rest with the restrictions. I want to turn to the importance of different kinds of resistance outside the law. So restrictions on funding, this was just this week, was the 43rd anniversary of the restriction ban on federal funding for abortion. It's called the Hyde Amendment. It came just 3 years after legalization. And for poor women and who are disproportionately in this country, women of color, that was pretty much their right to legal abortion not being upheld. Parental involvement laws, which require that a parent be informed or give consent. So-called informed consent, which is forcing doctors to lie, to tell people that abortion causes mental health problems and breast cancer. The expansion of religious refusals. The opponents of abortion call these conscience clauses, but really they are refusals based on religion of the provider, and the religion of the pregnant person doesn't seem so important. Targeted restrictions of abortion providers, these are so-called trap laws. These are medically unnecessary hyper-regulations of abortion clinics, which cause a lot of clinics to close because they can't afford to stay open. And finally, and tremendously emboldened by the current political situation in the United States and the occupant of the White House, the anti-abortion movement is getting bolder in terms of the kinds of laws it's trying to pass. So passing bans as early as 6 weeks of pregnancy, which probably you all know is before most people actually know they are pregnant. So if you're banning at 6 weeks, you're effectively banning all abortion. And lastly, the restrictions on telemedicine. We have just learned that about 40% of abortions in the US are abortions with medicines, with pills. And a combination of mifepristone and misoprostol. In much of the world, misoprostol alone is used, and I'm not going to talk much about that, but I think people can ask about it if they want. And so the restrictions on telemedicine are really aimed at trying to shut down what is becoming increasingly common abortion practice. So what to do about all, these are all the trends in restricting abortions, which we are facing as legal challenges to legal abortion in the United States. So I want to first do say some things about what it means to ground abortion in real people's lives. I think the first thing it tells us, I think these are guides to how we should think and act. So it tells us that we need to look intersectionally to understand that the people who are most vulnerable because of their class, their race, their age, their gender and sexual identity are the people who are most harmed by all the restrictions. People with economic security can almost always get an abortion anywhere in the world, no matter what the law. So really what we're talking about is using the bodies of the most vulnerable people in society as political footballs in this battle. Secondly, increasingly activists are adopting a reproductive justice framework which brings abortion into the realm of human rights and social justice. It's a broad approach, and I just want to read something from a press release. A court just blocked a 6-week ban in Georgia. It's not the end of the story, so it's not, it's going to come back. But the press release, which was issued by Sister Song, Women of Color for Reproductive Justice, reads very differently from the way these things have usually read. It says, "We refuse to go back to days where bodies are controlled by the state, and we oppose any policy violating bodily autonomy and human rights." So invoking these very broad, it's not using the language of choice, right? It's going for a much bigger understanding of where abortion sits in the lives of people. I want to say that a lot of people are afraid of broadening the frame for abortion. Afraid, people especially of my generation, who are afraid that if you get too broad, you're abandoning the fight for abortion. And really, I don't see it that way. I think emphasizing the interconnections of how abortion takes you to all of these other rights and needs is actually going to protect it more. And this, to me, takes, I think, a really obvious point, but sometimes an obvious point has to be belabored. The need or demand for abortion does not change with restricting it by law. That is so obvious everywhere in the world and here too. All it does is either force people to have babies that they did not plan or want to have, or and pregnancies that they consider unsupportable, or to go outside the law, sometimes having a dangerous procedure or not. So I want to now move to the importance of feminist activism outside the formal medical system and often outside the law. And just one last thing about the courts. I wish I could adopt all the judges we'd heard from this morning and put them on the Supreme Court of the United States, but that is not going to happen. And right now, we're really afraid of our Supreme Court. We don't want to take cases to it because it's a dangerous place. So the call, and I hear all of these facts and cases and the picture of abortion globally. I actually hear this as a call to action. And I think that we see that you can act in many different ways to achieve reproductive health rights and justice. But in order to do that, you really need to go beyond the law. It is actually the activism that motivates the changes in the law. And unfortunately, in this country, there's been a lot of persistent activism by the opponents of abortion. I think it's also a time for really bold action. Many of us some of us in this room, it's a young crowd, spent a lot of time in the 80s and 90s outside of abortion clinics doing what was called clinic defense, which is putting our bodies in front of the clinics. I was thinking when you gave that admonition in the beginning, whether it was directed at us, the thing about not being disruptive, we were disruptive because we were trying to ensure that people could get what they needed against others who were trying to shut the system down. And I think that same determination and commitment to people being able to bodily integrity, bodily autonomy, people being able to manage their own reproductive lives and future. I think that is what is driving today the activists who are assisting people in self-managing their abortion with pills. So there is abortion with pills inside the medical system, and then there is abortion with pills outside the medical system. You can buy them on the internet. You can find the protocols on the World Health Organization's website. You can Google SAS, S-A-S-S, self-managed abortion, safe and supported, to find this out. And so many countries in the world, no matter what the status of abortion, advocates are supporting people in this way. 20 countries have hotlines, even ones where abortion is highly restricted. Women Help Women and something called WOW, Women on Web, work with local networks to distribute pills. These pills, I should say, are in most states in the United States highly regulated and are a felony. So this is really, it is a place where law could change and policy. It does involve risk, but again, the risks here are not risks of the medical aspects of abortion or the biological aspects. They're risks imposed by law. For those of you in the audience who are going to be lawyers, there's a lot to do. You can work directly with individuals and advocates. 21 people in the United States have been prosecuted in the way that Jocelyn describes for allegedly self-managing their abortion or having miscarriages. And I think there's a group called If, When, How, these are activist lawyers who are defending women who are in that situation. And I just want to close by reminding us, September 28th was the day of action for safe abortion everywhere. I feel like all over the world, people are answering the call to action, which gives me hope and inspiration. September 28th was picked. It started in Brazil because it was the day that slavery ended in Brazil. And compelling someone to carry a pregnancy to term against their will is, in effect, a form of slavery. Thank you.
Do we have time for a couple questions? Maybe one?
And also, if you would like to.
Yeah, please.
Oh, yeah.
Yeah, how about we take one question, then I have a bunch to add, so let's take a question, then we can weave it in from there. Yeah, go ahead.
Minerva Rivas, a visiting fellow at the Petrie Flood Center. I have a question that I really listen with loads of attention, and so your very inspiring talks, and thank you for sharing. And I have a question that is also relevant to the previous panel, and it's to do with intersectional issues in abortion. As you rightly mentioned, this has a disproportionate effect in the most vulnerable part of the population. And also in what are your thoughts even if legislation is achieved, and we know that obstetric obstetric violence is a big issue in Latin America. Institutional discrimination is a big issue in Latin America, and physicians and other health professionals imposing their views despite the law is something that is very difficult to address and very difficult to battle. And yeah, I would like to have, if you could elaborate on that, please.
Thank you, excellent question. One of the things that I have been noticing in evaluating the many court cases with these women is that there's definitely an issue of discrimination, but there's also definitely an issue of training, right? And so for the case of Imelda recently, one of the things that the prosecution was arguing, or excuse me, the medicina legal, so like the state forensics expert supposedly was arguing, they said that there's no way that that an umbilical cord would rupture in a situation where a woman sat down like this. And therefore she had to have cut the umbilical cord with a knife or with scissors, and therefore that proves that she's guilty, right? So all I had to do, I'm a sociologist, right? But I've learned tremendous things. So one of the things I do is I just go to the PubMed database and I put in rupture of umbilical cord, and 17 articles come up that all say that an umbilical cord would absolutely break in this situation. There's even like diagrams of, they've had all these umbilical cords donated and they're stretching them to see when they'll break and things like this. And so what I do is I take those relevant parts and I translate them into Spanish and I send them off to be used in the defense of these women. So I think, and when you start looking into it, you realize that none of the forensic pathologists in the court systems in El Salvador have ever had any training in forensic pathology, which is actually a huge problem in the United States as well. We have a huge dearth of forensic pathologists in the United States. So you have people who have no training, they don't have access to PubMed, and they have to come up with their arguments. And so that's when these very discriminatory ideas about gender that are informed by what's going on in the public, I think, come into the court situation. I don't know if you've heard of the case of Evelyn. She's been in the news a lot lately. The forensic pathologist in that case actually made a statement that says a woman cannot give birth sitting down, right? Like they actually are coming up with birthing chairs right now so that you can give birth sitting down, because it's one of the best. So I think there's, it is a huge problem. I'm sorry, there you are, thank you. It is a huge problem, right? It's not just combating the discrimination, it's combating training. And I want to make clear that this is not just in Latin American countries, this is true in our nation as well. And I think this is also a call for us as universities, right? Like what I've found in these cases is that I need to get this forensic pathologist and this psychologist and this OBGYN to come together and to read these cases and to help us fight for these women. But I've also been able to sort of pull that information into training programs. And is there a way that we can use Harvard X, or that we can use the resources of the law school to make the information that's so easily accessible to us more accessible to the people who use it on the ground in the US and abroad, so that when there is that one person in the office who says, that doesn't really sound right to me, that an umbilical cord can't break, that they will actually have the ability to go get that information themselves. And so I'd like us to think about ways that information could be better distributed. It is also a problem, I think, in El Salvador that they don't train anyone how to do an abortion anymore. So even in the cases when the life of a woman is at risk, and they get some sort of permission to interrupt the pregnancy, the only option they have is they give her Pitocin, and they instigate an early labor, which is much more difficult for the body than other aspects.
Yes to all of that, and I think we just really do have to continue to call out the devaluation of women's bodies, women's ability to make their own decisions. I was struck there was a case recently this summer of a woman named Marsha Jones in Alabama, and she was in an argument with another woman. The other woman shot her in her pregnant stomach, and then Marsha was charged with damage to the fetus because they said she started the fight. So to me, what this says more than anything is that even a dead fetus is more worthy, has more value than a living woman. So I guess I think a lot of this is, we can help by giving information and knowledge, but until we completely destabilize the system, which devalues the ability of a person who is pregnant to make their own decisions about their lives, I don't think we're going to get very far. And for me, I mean, I'm sort of heartened to hear about the invoking bodily autonomy and human rights. You don't hear that in U.S. courts, but you know, there's a new generation here, so you go get them.
For me, what this question brings up is the systemness of the abortion issue, and I think what we've done when we've discussed abortion as whether or not women should have the right to decide whether or not they can do it, the public health and healthcare system has then extracted itself from the conversation and is kind of left of, well, then when the judges decide what to do, then we can figure out what we do. In the meantime, as we've seen, women aren't getting the services. And from a clinical perspective, you know, when you say doctors in El Salvador don't know how to do abortions, I would say that across the world, midwives and nurses are not trained to do abortions.
Right.
It's a doctor thing. You have to be a doctor to administer 4 pills of misoprostol, which apparently require a high level of training. Canada and the US, the midwifery associations have argued this and are trying to legislate an expansion in prescriptive capacity to be able to prescribe misoprostol, but heaven forbid that we actually learn how to do a manual vacuum aspiration. We can actually do a delivery, but we can't do a manual vacuum aspiration. And this also has to do with who's going to the hospital. In order to train to do any clinical procedure, you need to be able to do it, and do it a lot. When I was trained, I was trained in a place where I did 17 abortions a day, and that's a lot. And by the end of 2 weeks, I pretty much knew what I was doing. Unless you have that level of clinical experience, you're not going to be a safe provider. And if you're working in isolation in a place where your colleagues are looking at you and they're pressuring you not to do this. I get calls all the time from women in hospitals in Mexico that are like, I've been sitting here for 3 days bleeding and nobody's taking care of me. And they will have to sign to leave the hospital and come to a place where we can finish the miscarriage or the abortion or whatever you want to call it. In terms of systemness too, I think that removing it from the sphere of public health, we've actually removed it we've removed the conversation of what happens when people fall in the cracks between the legal decision and the actual clinical access to it. So just as you were saying, Marlene, between the time that the courts are deciding, the years are passing, and every month women are getting pregnant. And I want to call into that, just mention the fact that not only is it intersectional, where it's obvious that the most vulnerable are most affected by this, and I just want to point out an example. In the highlands of Chiapas, women don't monitor their period, usually because they're breastfeeding from the time they're 15 till about the time they go into menopause. Their periods are pretty irregular. They, during the coffee season, will definitely see the ovulation happens less because they're working long hours and eating a lot less. It's very difficult to realize that you're pregnant. There aren't pregnancy tests at CVS because there aren't that many pharmacies. You wouldn't spend your money on a pregnancy. By the time Indigenous women in the highlands realize that they're pregnant, they're very far along. And by the time they start asking in secret a network, where can I go? Can you drive me somewhere? Where can I go where I won't die because I have 4 other kids, because the coffee season is coming up. By the time women are actually accessing care, they're very, very far along in their pregnancy. So again, going back to the systemness, it's not just about ensuring access, it's ensuring that access is tangible in the way that we understand what conception is, what pregnancy is, and when and how and where to access that care as quickly as possible. We've talked a lot about time.
The only thing, and another thing to add in terms of the public health professionals, and in El Salvador, in the United States, in South Carolina, where women are prosecuted for taking illegal drugs while pregnant, it's doctors and nurses and people who are working in the hospital who are turning these people in. And so part of the educational process here is again, not just knowledge and information, but values and morality, and sort of centering people, and so that medical professionals don't actually feel so emboldened to take charge of decisions, over other people's bodies and lives.
We certainly, in the world of maternal and sexual and reproductive health, we feel the need to have opinions about all the processes that women go through, which doesn't happen in oncology or,
Right, exactly,
you know,
exactly.
in other fields. Does anybody else have any questions? Okay. I do want to, as a matter of closing, I do want to highlight that we're all involved in this, and to me, this is such a global issue. And I'm going to cite another example. There's a network in Mexico that was actually mentioned by one of the justices. There's a hotline in Mexico where you can call, and they will get you to Mexico City, get you to a safe abortion, and get you home. That service is completely free. It's completely anonymous, and you actually get to choose what clinic you go to. It can be public or private. You get an abortion doula who's with you the whole time, and you get a hotel room the night before so that you can rest if you actually have time. Most of the women spend the night on the bus coming to Mexico City and then go home as quickly as possible because they have jobs and children. That network is funded by donors in the US. And it only exists because of donors in the US. If those donors need to start funding the same network to exist in the US, it probably will stop existing in Mexico. The reason that we get mifepristone is because there's a donor in London that sends it through suitcases, and we get it. Until it was recently legalized in Mexico, but until then, people were bringing the mifepristone in suitcases, and we used to send misoprostol to Chile, stuck on T-shirts so that it would get through the mail to midwives and doctors there. So I just want to talk about that, you know, Women on Waves is a perfect example of this, but all of us are implicated in the global capacity, restriction, access to whether or not women die of an abortion or they actually survive it.
Right, and the network of abortion funds that I work with in the US, and the Maria Fund is part of that network, and basically it's doing what the state doesn't do. Unlike in other places where abortion is made legal and then it becomes an affirmative part of the public health system, in the US, having the right to an abortion never meant that you had the right to access abortion. So again, that discrepancy between the two means that private actors and activists are trying to fill the gap, which is enormous. You can't do what the state should do in these cases. So I think again, it's like until we are living in that world of justice and reproductive justice, where all these things are available and paid for, all of us need to do what we can do to make it happen. Thank you. Thank you, Chris.
So thank you, everybody, for being here this morning. I think it was a
Thank you,
very productive
Christine.
discussion.
Thank you. It's great.
So
Can we go down?
I really want to thank that last panel for bringing to life some of the issues that we've been discussing throughout the morning with extremely passionate and articulate stories. I think it's throughout the morning we've seen that this issue has so many different facets from which you can understand it. And that looking at it sometimes from the local, very contextual perspective to the global trends. It's not just the women's movement and the funding in terms of progressive abortion forces, but also the anti-abortion forces and the forces that are at the European Center for Law and Justice or the American Center for Law and Justice, in which the president's personal lawyer sits, foment anti-abortion legislation that is cut and pasted and other funding of networks. I think it's also brought to light the kind of inextricable relationship between how we think about health policy and health system organization and the legal frameworks that organize that, but also the gaps between permissive legislation and effective enjoyment of women's rights in practice. And finally, I want to just underscore what a privilege it has been to hear sitting justices of the Mexican Supreme Court speak so candidly and openly about you know, the work that they are doing now and faces them now, and to have Judge Sayo join in that conversation. So thank you very much. Please join me in thanking them.